You hear all those stories about nightmare HOAs, right? But have you ever wondered what happens when things get so bad they actually end up in court? Well, we're about to find out. Today, we're going to dig into an official court document, a real case file that lays out a legal war between two residents and their homeowners association. No rumors, no gossip, just the cold, hard facts. All right, here's our game plan. First, we'll set the scene and meet the contenders in this neighborhood showdown. Then, we'll get into the weeds on the two big complaints they filed. After that, we unpack the main event, something I'm calling the garage incident. And finally, we'll see what the judge had to say about the whole thing. So, let's set the scene. We're in a community out in Tucson, Arizona. Things have gotten tense, and two homeowners have decided they've had enough. They're taking their own governing body, the Maravilla Neighborhood Association, to an official hearing to settle the score.
Okay, so in one corner, we have our homeowners, Charles Starr and Donald Nevins. They're residents, they're members, and get this, they're representing themselves, no lawyers. And in the other corner, you've got the association, the HOA, and you better believe they brought their legal counsel. The stage is definitely set for a battle. Let's jump into the first major complaint that landed on the judge's desk. And no surprise here, it's all about the money. The homeowners were arguing that the association just wasn't keeping its financial records straight, especially when it came to the community's reserve funds. So, what was their main piece of evidence? They actually used the HOA's own rule book against them. They pointed right to this rule, which says the association has to maintain detailed accounts. Their whole argument was, look, whatever you're doing, it's not detailed, and we think something's fishy. We want the court to step in.
So how did the judge see it? Well, it was interesting. The court admitted that, yeah, the books were a bit of a mess before February 2007, but they'd been fixed since then. And here's the real kicker. The judge pointed out that the bylaws already have a solution for this. If you want a full-blown audit, you just need to get 25% of the owners to agree. The judge basically said, there's a process for this in your own rules. Go use it. Okay, on to the second complaint. If the first one was about money, this one was all about access to information. The homeowners were claiming the HOA was flat out hiding documents and blocking them from looking at the records. And folks, this is where the story really takes a turn. Now take a look at this rule. It sounds so boring and bureaucratic, right? At convenient hours on working days. Believe it or not, this simple little phrase is the fuse that's about to light the fireworks in this whole case. Everything hinges on this. So here's the setup. The association doesn't have like a corporate headquarters. It's run out of people's homes. So all the records, which the court described as voluminous, are sitting in a bunch of bankers' boxes at the HOA president's house. And our two homeowners, they show up ready to work. They even brought their own copy machine. They meant business. And all of this leads us to the main event, what I've been calling the garage incident. Yeah, you heard that right. An inspection that kicks off in a living room is about to get very, very tense out in the garage.
So let me walk you through the timeline. It starts on a Friday morning, and they're all in the president's living room, going through boxes. But it's a huge job, so they don't finish. They agree to come back Saturday. The catch? The president's 5-year-old is home on Saturday, so he asks them to move the whole operation into the garage. And that's where things go south. A fight breaks out over something as simple as whether the garage door should be open or closed.
And this is where it becomes a classic case of he said, they said. The homeowners testified that a group of other younger men showed up and started intimidating them. But the association told a completely different story. They claimed those were just a few curious neighbors, wondering what on earth was going on in the president's garage on a Saturday. Two totally different realities.
So what do you do with that? You have conflicting stories, serious accusations. How does a judge possibly decide who's telling the truth? Well, it all comes down to a really important legal idea.
Before we get to the verdict, you have to understand this term. In a criminal trial, you need proof beyond a reasonable doubt. But this is a civil case. The standard is called preponderance of the evidence. All that means is that the people making the complaint, the homeowners, have to convince the judge that it's more likely than not that their story is true. We're not talking 100% certainty, we're talking 51%. They just have to tip the scales, even slightly, in their favor. And this one sentence from the judge's final decision is the legal knockout punch. The court found that the homeowners just didn't get there. They couldn't tip those scales. They failed to meet that greater than 50% standard for any of their claims.
So with that, the outcome was crystal clear. Case closed. All the homeowners' petitions were dismissed. So why did they lose across the board? Well, the judge's reasoning is pretty insightful. On the financial complaint, the books were now in order. Problem solved. On the document inspection, the judge actually said the HOA went above and beyond what the rules required by letting them inspect on a Saturday, a non-working day. And as for the big garage incident, it was one person's word against another's. And without more proof, that just wasn't enough to clear the bar. And this whole case really leaves you with a big question to chew on, right? In these communities, who really holds the power? Is it the black and white text in the rulebook and the people who enforce it? Or is it the residents who have to live there every day? It's definitely something to think about.